General Delnott, thank you so much. You've been very supportive of my my academic efforts over the years, so thank you very much. I want to just start off the panel. I think we've just done some of the introductions, so let me just get right into the substance of it off the top and just answer the two questions that are probably on everybody's mind about space. First one that I get all the time is, why is there a Space Force? So if you don't understand the importance of space to national security, you really need to, because it is so key, not just within the military, but within the civilian system. So every time you do pay at the pump at the gas station, that is a space-enabled effort because of the precision navigation and timing that those pumps use to key in your credit cards to make your credit cards work. It is a multi-billion-dollar industry. I am from Wisconsin. My parents bought 40 acres of farmland up there, and so when I go up and watch how planting is done now with the tractors, it's the planting, the seeds are all put in through the GPS, again enabled by the precision navigation and timing, and it is so important to the economy from those standpoints. From the military, I think it's been clear to everybody, at least since the Gulf War in 1990, that precision navigation and timing is a critical enabler of all of our forces in all the other domains. So we get our secure communications through space, we get precision targeting, precision timing that you need, that is all space enabled. So all those precision capabilities that we see that we rely on are enabled by space. What's important there is our adversaries recognize that. And so adversaries like Russia, China, even North Korea and Iran, they look at those capabilities and they realize that if you want to take on the US military, space could in theory be a critical vulnerability. And so what we've seen in the middle of the 2000s through the current time is our adversaries using these direct ascent anti-satellite weapons, kinetic rockets, if you will, that go into space and can take down other satellites that leave a lot of debris and that are very destructive. They realize that debris and that destructiveness can interfere with their own space capabilities, so then they look at getting more exquisite and better capabilities to try to take on our space assets. And as that effort has been picked up by our adversaries, the President, the administration, Congress recognized that you need a service dedicated to protecting and defending that space domain and making sure that we have all the other assets enabled in those terrestrial domains, if you will. So that's why in 2019 the Space Force was created. The second question I get asked, and I think I've been asked it about 5 times since I've arrived here, is will there ever be a Space Force JAG Corps? And I think the answer to that is maybe at some point in the future. Right now, the Space Force is not terribly large. I think active duty-wise, it's about 4,000 to 5,000 people. It may grow a little bit from there, and then I think if you double that, you can get the civilian numbers. It's really not enough to sustain a full-time cadre of pure space JAGs. And that's the reason why it's nested within the Department of the Air Force. The Space Force itself has 4 career fields, just 4. It's got the space operators, the ones who fly the satellites. It's got space intelligence professionals who utilize the satellites for imaging. It's got cyber, because in order to communicate with space and get the satellites to function together, cyber is a critical enabler. And acquisitions to be able to be experts in acquiring those systems. Everything else the Space Force gets, it gets from the Department of the Air Force. And so when we have the Space Force units that are aligned to the geographic combatant commands, they go back to the Air Force for that legal advice. So if you have a pure Space Force JAG Corps, those space staffs are not enough to really, because they're such small teams, or 20 to 15 people, it's not enough to generate a full-time billet for a judge advocate. So they rely on the Air Force expertise that's been there for decades to provide that to them. And also because of that small population, the other thing that we in uniform deal a lot with is military justice. You're just not, if you have a purely dedicated Space Force JAG Corps, they're not going to get that justice proficiency that you need to be able to consistently give advice. So we're well used in the Space Force, but we're used critically, and I think at least in the foreseeable future, till the Space Force really expands, maybe when we colonize Mars, there's just not enough critical mass for our own Space Force JAG Corps. And so I just wanted to lay those two questions out because, again, those are the questions that we get asked all the time. So you're not going to hear that much more from me as far as a narrative goes. We're going to go over to the panel, and I'm just going to throw things out. We don't have rehearsed answers for all my questions and scenarios that we're going to go over, and I'm going to hand off the microphone and then sit down in a second. But I just first want to ask, and we'll start with Chris, to just discuss some additional thoughts he may have on the relationship between space and national security.
Great. Thank you, Colonel Richard. And first, just to begin, I just want to thank General Dunlap and everybody on the LENS team for an absolutely incredible conference. It's an honor to be here with all of you, and also to thank you in terms of the work that you're doing with the LENS scholars. Two of my students are here, and this is just an incredible opportunity for students. So thank you so much for your incredible work. As Colonel Richard had mentioned, I'm going to say just a couple of words, sort of framing a little bit of what he was already mentioning. Please just tell me when I should stop. I'll take just a few moments to talk about a little bit about how space has become so important, and then a couple of words about sort of generally about sources of law, something that we're going to be spending a lot more time talking about on the panel. So in terms of all of these activities that Colonel Richard was describing, in terms of how ubiquitous space has become in terms of our economy and also our national security, how did that happen? What has changed? What is this sort of revolution in space activities that people are talking about? Well, I suggest that one of the things is basically a change in cost, and this has to do with a change in technology. So historically, it has cost perhaps $20,000 per kilogram to send something into Earth orbit. That has decreased with the use of reusable rockets, smaller rockets, other types of new technologies. That's decreased from about $20,000 per kilogram to about $2,000 per kilogram. And it's going down further from there. What that means, and I should say, and the second thing besides it being cheaper per kilogram, because of the revolution in electronics and microelectronics, satellites have changed in size. So if you think about Sputnik as being, sort of like a beach ball sized, right? Now, the satellites we have in orbit range in size from the size of a postage stamp to the size of a school bus. Some of these are maneuverable, some of them aren't. That all leads to, and they're all moving around the Earth at about, in low Earth orbit at about 17,000 miles per hour. So that leads to an environment that can be very dangerous, but that's also where we have a lot of critical national assets. What that means in terms of sort of cheaper costs is that there are more states with satellites, and it's not just states. You have middle schools that have middle school projects sending up a satellite on a private launch. So you've got something that used to be the domain of the quote-unquote superpowers is now something that is a middle school project, and everything in between in terms of the different types of space actors that we have in space. So currently in 2005, I should say, there were about 217 active satellites. I'm not counting space junk. The active satellites, about 217 in 2005. There are currently about 7,000 active satellites, and the number is increasing each year by perhaps 1,000 or so. They are operated by 74 countries. It used to be 2 or 3 countries. Now it's 74. So in terms of this, what you have is an environment that has changed a great deal. Now, a couple of words about where these satellites are. To paraphrase Lori Blank and Colonel Matt King, space is infinite, but the locations that are strategically interesting are finite. So we talk about orbits, things that I'm sure everyone has heard about, things like low Earth orbit, about 60 miles up to about 1,000 miles up. You have a lot of military reconnaissance satellites, civilian remote sensing, the International Space Station is there. Then you could think about medium Earth orbit, which is above 1,000 miles. That's where you have things like GPS. Then you could go all the way out to geostationary orbit. That's where the time it takes to orbit the Earth is the same as the time that it takes for the Earth to rotate. So you're basically able to hang a satellite over a particular point on the Earth. And that's geostationary orbit. All of those are valuable for different reasons. But not everything is sort of equally valuable. So a couple of words then in terms of the law that's used in terms of regulating all of this. If we're doing this as sort of, a semester class, there would be a whole range of areas of law that we would look at. We look at public international law. We look at domestic law, foreign law. We look at contractual obligations as setting up obligations between private parties. We'd also look at non-legally binding norms that set up expectations. We don't have time to do all that. I'm going to just focus in for one moment on public international law. So here we think about treaty law and customary international law as the two main sources. Even within that, let me just focus in for a moment on treaty law. So within treaty law, since we're talking about military space activities, we're going to think there are various things like the UN Charter in terms of the use of force, the various treaties having to do with international humanitarian law. But what I want to mention in particular are the treaties having to do with space. So there are 5 main space law treaties: the Outer Space Treaty, the Rescue and Return Agreement, the Registration Convention, the Liability Convention, and something that's called the Moon Agreement, which I'm going to set aside for the moment. Within those, I'm just going to focus in on one for a moment, the Outer Space Treaty. That's the main framework agreement that was made in 1967. Within that, the states, and it has pretty much every spacefaring state and space launching state is a signatory. It includes obligations such as no weapons of mass destruction in Earth orbit, no military bases on the moon or other celestial body, no weapons testing on the moon or other celestial bodies, that space is for peaceful purposes. So there's a lot of language there that might relate to aspects having to do with national security and military space activities, things that we'll be talking more about in a few moments. So, and of course, there's also customary international law. And one of the things I'll just leave as a question in terms of customary international law is whether or not state practice that was primarily terrestrial causes customary international law in terms of its application in space. So, in closing, why did I sort of do this sort of focus in narrower? It's not just to focus on the sort of the narrow point of sort of this particular treaty or what have you, but it's to point out that besides that narrow focus, there's all these other sources of law that interact. So one of the things that we're going to be talking about is to what extent does the Outer Space Treaty, to what extent does it apply during a time of armed conflict? By contrast, to what extent do various rules of international humanitarian law apply in space? And what happens if there are potentially conflicting obligations? So that's more of what we'll be talking about in the next few minutes, but that's just sort of to set the scene a little bit.
Thank you very much. Commander Reynolds, can you talk a little bit about the ethics issues involved?
Yes, absolutely. And I'd like to start, just like Professor Borgen, and thank Lens and General Dunlap for allowing me to be here with my august colleagues. And it's such an honor to be part of this group, and I'm grateful to be here. So thank you, General, for making me a part of it. Now, Professor Borgen cited Professor Blanc, but I'm going to cite Homer Simpson. Space is finite so far. Part of my job as a Navy judge advocate is ensuring that we preserve commanders' decision space so that troops in contact or sailors on the water are able to exercise the discretion that they have under law and policy to both meet mission, secure the safety of platforms, and also secure the safety of those sailors that are on board those ships at sea. And we talked a little bit about the law, which is great, and ethics is part of the law. At least it is for active duty military people. I've been an ethics counselor for many years. I've advised on military operations as well as ethical considerations as they apply in the water column, on the surface of the water, in the air, in international waters, and in domestic waters as well. So what is ethics in outer space? What could that look like? Now, I'm not talking about something like VCNO's Standards of Conduct Guidance that provides statutory regulation through an executive order. So those constitutional considerations from Article 1 and 2 going through statute down to whether or not you can use a government rental car to go through the drive-thru at McDonald's. I'm not talking about that. That's important too. What I'm talking about more generally is something the philosophy of law refers to as an incompletely theorized agreement. So I think most nations and most individuals would agree that concepts of ethics are applicable terrestrially, and they're also applicable in other domains that are explored by civilian practitioners, corporations, as well as military. And that includes areas outside the jurisdiction of any one state, of which outer space is one. So what would ethical considerations in space look like? Well, I think we're going to talk in more detail about Dr. Nasu and his thoughts on the law of armed conflict and his excellent work on targeting satellites, but also we can think about that in terms of ethical obligations as well. Now, these incompletely theorized agreements are useful because the general principle that ethics are applicable no matter what we're doing or where we're doing it, that's incompletely theorized. We might all agree that ethics are appropriate to apply in outer space context, but what does that mean exactly? That's the incompletely theorized part. Now, part of my work that I've been doing on my PhD is specific to due regard, but also to ethical obligations through the context of the Golden Rule. Now, before I really started reading about it, the Golden Rule seemed to me to be one of those like silly childish concepts that maybe a 5-year-old would agree with, but certainly, competent adults and military commanders don't think like that. But it is one of the few concepts that has purchase in most faith communities. It's one of the few concepts that shows up in a very broad Eastern and Western theological consideration. So if we can think about that, do unto others, if you're thinking about it through like the New Testament, or treat your neighbor as yourself, as it's expressed in the Torah, or when you think about it from the Hindu perspective, which actually kind of matches up with the Confucian concept of don't do to someone else what you don't want done to yourself, you can see how that broader construct that most of us would agree is something that should be applicable in any human interaction, whether it's military-based or corporate-based. You can see how that agreement can maybe give us a place to start. Mr. Chang, Dean, was talking yesterday about industrial standards. And in the absence of a standard, whoever it is that goes into that space and starts that foundation is probably the one that's going to control. I don't know about you all, but I'm a huge science fiction fan. And when he was talking about that, I was reminded of Firefly. And I don't know, those of you who've seen that show, there's Chinese language scattered throughout that dialogue because that's the language in space. So what ethical language are we going to have in outer space? What ethical obligations are going to be the foundation from which we start our conversation on those activities? Well, part of what I'm writing about is due regard as a consistency norm, which in my view is similar to the Golden Rule. And so, a lot of this are just thoughts in my head that I'm trying to write. And maybe you've heard the old trope about how writing is really like sitting and staring at a blank keyboard until blood comes out of your pores. That's kind of how it feels sometimes. But being able to be here with all of you and my colleagues and kind of get nerdy with other lawyers about these concepts is very helpful to clarify my own thinking. And I hope it's something that we can continue talking about now, because national security law and ethics is something that matters. Another part of my work is the prophylactic effect of ethical obligations on military service members to protect them from their individual harm that they can suffer from being asked to do things like blow things up and kill people. That's something that we as a society will have to decide how we want to be. And those ethical obligations that for me as an active duty Navy practitioner are baked in from the very beginning. The Naval Academy has leadership and ethics as a component part to education. It's something that we talk about from our earliest times before we're in command of anyone but ourselves, all the way through to being a 4-star. And I think it's something that we need to talk about here as well as it relates to outer space. So I've probably talked more than I should, but thank you so much for the chance to be here, and I look forward to talking about this in more detail.
Thank you. And so I'm going to go to Dr. Nasu next, but when I go to him, I'm going to tee up first. I would say it's a hypothetical, except it's not exactly a hypothetical. So, but because he's written on targeting of satellites and some of the law of war implications, let's just look at the real world example that we can draw on from 2023, with the Russia-Ukraine conflict and the utilization of Starlink, which is the SpaceX-enabled low Earth orbit satellite constellation. I don't know if any of you have actually used Starlink, but again, you've heard me say I'm from Wisconsin. My parents have a farm out there. They had really bad internet, DSL, slow-loading internet. I read about Starlink in the Wall Street Journal and just went online and ordered a Starlink set for their house. Set it up in about 5 minutes when it came in the mail, and all of a sudden we have high-speed internet in rural Wisconsin. And it's a pretty awesome capability, and I think we've seen it in the news with, and that's no endorsement for me in my official capacity, by the way. But it's been in the news because how the Ukrainians have relied on it for their secure communications, and Russia's frustration and inability to jam it, because the receivers are fairly transportable and they're compatible, and it's kept Ukraine online and in communication and enabled to do certain things. And there's other satellite communication, private commercial satellites that are also partaking in the Ukraine conflict. So with that, I will now turn it over to Dr. Nasu, just with that stage setter, to talk about how the law of war applies and when do these commercial capabilities become lawful targets.
Thank you. And let me first of all echo the thanks that my other panelists expressed. And I'm extremely grateful for this opportunity to talk to this audience. It's my first time to be in North Carolina, so it's a great adventure to me. Now, I think before we talk about that particular scenario you described, I think I have to perhaps explain the sort of technological background, which is important to appreciate the actual sort of issues that we are grappling with. I think there have been a couple of people who are talking about the importance of knowing your client. I'll expand that to knowing the subject matter you are dealing with. So here, as Colonel Richard talked about satellites, a lot of satellites, and his scenario talks about communication satellites. Communication satellite is only one type of a satellite you see. But there are other types of satellites. So you have to actually understand the functionality of each of those different types of satellites before we talk about the targeting and then the different ways in which you can actually disable their functions. So as of those 7,000 active satellites, the majority of them are communication satellites orbiting the low Earth orbit. And there is also GNSS satellites, which is used to send PMT signals for navigation. The constellation number is not as great as a communication satellite, but still a sizable number. And each state has a different GNSS satellite constellation. For the US, the most famous one is GPS, but Europe has their own version of it, and also China and Russia has their own version of it. And there is a more critically, more militarily critical satellites, such as Earth observation satellites, which actually monitors what's going on Earth's terrestrial context. And it's not just capturing the images from far above the Earth. It also has quite interesting technological features that enable basically penetrating even the sort of buildings and then see inside that building. So there are different types of observation satellites also orbiting, and then perhaps a small critical portion of it is a missile warning satellites. So those are sort of in a very sort of rough grouping. Those are the 4 different types of satellites orbiting the Earth. Now, how can we disable them? There are different types of means of disabling those satellites. One, Colonel Richard highlighted, is an ASAT, the physical kinetic means of destroying a satellite. That can be done from the Earth, direct ascent. That can also be done from the space-based or airborne-based the missiles. And another kinetic means available is what we call RPO, the rendezvous and proximity operations. So use one of the satellites you launched has the capabilities of maneuvering and get close to another satellite and then destroy or otherwise manipulate by physical means. And on top of that, you have electromagnetic spectrum interference, such as jamming and spoofing. That's perhaps a more traditional and cheaper means of disabling or at least neutralizing the signals coming from a satellite. And then perhaps some more 21st century version of it is a laser. So laser weapons that can be launched either from the ground or from the air or from the satellite itself can also be used to disable enemy satellite. EMP is another one. There has been some report about the Russia's plan of using nuclear weapons against satellites. The key question is why do they want to do that? And what's the purpose of using big nuclear bombs in order to destroy just one tiny satellite? Probably the effect they're looking for is EMP, the electromagnetic pulse. Back in the 1960s, I think, there were 5 occasions where US and Russia conducted nuclear explosion tests in higher altitude atmosphere, or maybe perhaps passing into the outer space. At that time, of course, we had only a few satellites. The explosion caused EMPs, a massive amount of EMPs, and that neutralized all of the satellites that existed at that time. So now if you think about the 7,000 active satellites, and if you use EMP, just imagine the impact that may cause. That can be a quite effective means of destroying or disabling satellites, a number of them at the same time. And don't forget cyber. As Colonel Richard explained, cyber is a critical component and could well be quite effective means of disabling a satellite if your target is just one satellite or perhaps a communication system as a whole. So with that basic understanding of technology, then you have to think about, well, how does the law apply? Now, I think we are envisioning the situation where the states, well, let's assume, I think we are assuming international armed conflict in which the communication satellites becomes the immediate target. Of course, there's no reason to rule out the application of law of armed conflict. I mean, if the two states are in an armed conflict, law of armed conflict certainly applies, no matter where, no matter what domain military operations are conducted. The only exception I would add is there are certain rules under the law of conflict which are domain-specific. So yesterday we heard from Professor Kraska about the naval warfare and targeting law certainly applies. Targeting law applies differently. Or set of rules that apply to targeting in naval context are different to the targeting law that applies in a land context. So those kind of domain-specific rules won't apply to space, but the general rules of law of armed conflicts, particularly targeting rules, certainly do have a general application, even in the context of a space operation. So the question is then, if you're targeting communication satellites, well, if you're just knocking out one communication satellite, what's the effect? Probably not much. There's a lot of communication satellites, as I just explained. There are redundancy systems. Many of them are orbiting. So you may be able to create some gap in enemy's communication system, but not to a significant level. So if that is what you want to do, still, the question then becomes, whether that is a legitimate military target. That's where you have to apply the standard law of armed conflict, the object rule of targeting law. So you have to decide whether the communication system is by nature a military objective or because of its use for military purposes, or maybe even the location, if you're talking about some other satellites such as GNSS satellites. So you have to assess the sort of targetability of the satellites. Once you pass that, once you decided, well, this is a legitimate objective, then you have to think about, well, what are the consequences? What are the foreseeable effects it would cause? And if there's any possibility of causing a civilian harm, incidental harm, of course, you must take that into account as part of proportionality. But watch out, for the purposes of proportionality, what counts is the civilian harm, incidental harm. So the mere inconvenience that may be caused because of the loss of access to the satellite communication doesn't count. Okay, so that means that you only have to foresee, is there any other satellites that may be damaged or that may be destroyed? Or is there going to be any death or injury that will be caused as a result in a terrestrial context? Those are the only consequences you have to take into account as part of proportionality assessment. That's for the straight application of LOAC. But then, because you're operating in a space context, there are other bodies of law that also apply in parallel, particularly in your relation to other states that are not involved in an armed conflict. So in relation to, for your relation with other states, peacetime international law still continues to apply. That includes the space law. And under the space law, there's an obligation to exercise due regard for the rights and interests of other states to use and explore outer space. So if the action you're taking is going to cause a debris and may perhaps interfere with other states' rights or interests of using outer space, that can be, you can say that can be a clear breach of a due regard obligation. So that's another sort of a layer of legal consideration you have to add on top of the sort of straightforward application of LOAC rules.
Thank you. I'm going to turn it over to our other panelists to see if they want to comment as well on this particular scenario before I move on to our other ones. So,
thank you. Two things. I think Dr. Nasu did a fantastic job of covering, really covering the basis in terms of the main issues. I'm going to mention just a couple of things. One is in terms of the question of the various aspects of law that apply. One thing that I wanted to mention originally, but I had not, is one of the sections of the Outer Space Treaty is Outer Space Treaty Article 3, which notes that international law applies to space activities. And I think that's important just in terms of context, in terms of what we were talking about, which is one of the reasons why we look at things like the applicability of the law of armed conflict, along the lines that the law of armed conflict, as Dr. Nasu described, is applicable to any and all conflicts. Of course, what we need to look at, of course, is whether some of the sources of law are domain specific. So that includes then, in thinking about Outer Space Treaty Article 3, not law of armed conflict, and as well as other international obligations that a state might have. And a lot of the work at times of international lawyers is looking at some of those obligations and how they either translate into space or whether or not there are things that are domain specific and do not. Second point that I wanted to mention is actually picking up on one of the examples that Dr. Nasu had mentioned a few moments ago when he talked about the sort of the nuclear tests that had taken place in the upper atmosphere in the 1960s that had caused widespread destructions of basically all the satellites that were in line of sight with the nuclear explosion. And just mention that right now what we were just talking about a few moments ago was the question of targeting satellites during an international armed conflict. So it's a very, sort of very specific scenario. One thing that I want to mention is in terms of thinking more broadly about weapons in space and counter space weapons, is that a lot of the debates that are going on in the moment has to do with the question of weapons testing. And so as you might have heard, as you might well know, the U.S. has stated, I guess it was about 2 years ago, had made a unilateral declaration that it was not going to be testing direct ascent kinetic ASATs because of the debris causing problems that this would cause. Now, this is in part because there's been an increase in the testing of kinetic ASATs in recent years. The U.S. had largely been testing them starting back in the 1960s up into the 1980s, but China tested in 2007, India in 2019, Russia in 2020, and again in 2021. one of the areas that folks focused on space talk about is how it's going to be very difficult to have a new space law treaty. There's a lot of discussion in terms of sort of whether there's the political will. But this is one of the places where we see other aspects of diplomatic practice to try to set norms. So the U.S. has really been sort of at the forefront in terms of making statements in terms of decreasing the number of kinetic ASAT tests. Now, there's still all the different types of anti-satellite weaponry that Professor Nasu had mentioned, such as cyber and so on. Now, my closing point that I want to mention on this is why? Why do we see this sort of disparity? So we've talked about the 7,000 satellites in space. Of those 7,000 satellites, 4,000 of them are specifically from SpaceX. When you look at the total number of satellites, about 5,000 overall, including the 4,000 SpaceX, about 5,000 overall are US satellites. So the United States uses satellites and has an interest in terms of protecting the space environment that is perhaps greater than other states that don't use satellites to the same extent that we do. So this is why you've seen a lot of discussion from the US in terms of this, and at times there's been, what we've been seeing recently has been testing by Russia and China. So I just wanted to sort of mention that in terms of sort of one of the areas, before we get into an international armed conflict, or hopefully not having an international armed conflict at all, but just in terms of during peacetime, some of these areas that are areas of sort of debate and discussion.
Mayor Reynolds?
Definitely concur all with Dr. Nasu and Professor Borgen's excellent comments. What I would like to add is an emphasis on how a lot of these legal principles are frameworks that are adjacent to each other and sometimes overlapping one another. Professor Borgen raised the point, excellent one, that Article 3 in the Outer Space Treaty specifically mentions that international law is applicable when interpreting the treaty, which also means the Vienna Convention on the Law of Treaties is applicable, which also means that depending on the fact scenario, there may be other bodies of law specific to contracts, finance, environmental, that might come into play. And I think that's really important to think about. When we move on to our next topic, which will be specific to the Chinese high-altitude space balloon that we dealt with in, I think it was 2023, this adjacency and overlapping legal frameworks is an area where judge advocates and attorneys in general bring value to the fight. The operators don't need to know why a specific authority is applicable. They just need to know that the activities they're engaging in are within the scope of their authority. What the attorneys do is articulate the particular legal basis for the action. And we're fortunate in the US military in the sense that from a policy perspective, the law of armed conflict and other legal and ethical principles are baked in from the very beginning as a policy decision. So when I engage with judge advocates from our partner nations or other allied nations or nations that are not in the same legal paradigm as us, like counter-piracy is a great example. I did a cross-deck with the Marshal Shaposhnikov in 2009, and they don't have a JAG. They have a lieutenant whose job is operational restrictions. And so he's thinking in terms of mission accomplishment through that lens, which is quite different than my consideration as I'm advising the CTF 151 South Korean admiral on obligations under a UN Security Council regulation. Like those are different things. Now, does it get us to the same outcome? Sometimes, sometimes not. I mean, the counter-piracy paradigm, you end up with suspected pirates that you can see through satellite imagery are on the deck one day of the Marshal Shaposhnikov, and then the next day they're not. So what does that mean? I don't know, but I think that the Russian Navy has a slightly different perspective on how to deal with suspected pirates than CTF 151 or American vessels. So why is this relevant for outer space considerations? It's important because, as you've heard all along, as we are advising commanders, understanding the scope of authority, acting within that authority, and preserving that commander's decision space for additional actions is part of how we ensure that our rules-based order that's so important to NATO allies and other allied nations that are not affiliated with NATO is ensuring that that general concept is not only terrestrially applied, but applied as we continue to move outside of our legal regimes that we're so familiar with, whether they're land warfare or whether they're maritime warfare. There's always conversation about, do we need new law? And I think one thing that Dr. Nasu made very clear, we don't need new law. We need to creatively and accurately apply the law that we have. And the fact scenarios that exist on the water or in outer space will dictate the outcome. And we don't need new law for that. We just need smart lawyers and smart operators.
All right, this is a very rich area for people to write on and to think about, and we could really keep exploring commercial satellites during armed conflict and how they touch on contractor use, how they touch on neutrality issues. But we're not going to do that right now. I'm going to shift gears a little bit and get into the other scenario that she mentioned, which is the Chinese high altitude balloon. And for those of you that may have gotten online this morning, we had another balloon that was in the news yesterday that's over Utah moving towards Georgia. This one does not appear to be maneuverable from what I read on the BBC. Can't find any reporting in the Wall Street Journal, New York Times, or Washington Post yet, but maybe they've reported since I've started talking here. But at any rate, the balloon that we do know of from last year was flying around 60,000 feet. And as I think everybody in the room is aware of, we tracked it going across the United States, and once it moved over the Atlantic Ocean, it was shot down. So wanted to just turn it over to the panel to talk about where does space begin, and why are the Chinese looking at what they call near space, and what is near space, and what does it mean, and is it operationally or legally significant? So I think I'll go to Dr. Nasu first to talk about it, and then we'll have the other panelists comment.
Right. So the first question is the boundaries between the outer space and national airspace. So there is no, I think many of you probably are familiar with it, there is no sort of a set boundary between outer space and national airspace. There's no treaty language, there's no treaty provision setting the boundary, there's no customary sort of international law that sets the boundary. There has been a lot of debate about how the boundary should be drawn, and there are three different theories, I think. General sort of rule of thumb, or maybe general, it's not, I wouldn't say agreement, but general sort of height that is referenced usually is 100 kilometers mark. I'm not still familiarized myself with the American metrics, still using kilometers, but 100 kilometers is roughly the area where we can say that's where the outer space is divided from national airspace. But those balloons were flying much at lower altitude, so there's no question that they were violating national airspace, and the US has a sovereign right to shoot down any sort of aircraft entering the US national airspace in infringement of its sovereignty. But I think your question is, well, what if it goes further up? Now, of course, at some point, you may wonder, well, what's the difference between those balloons and satellites? Function-wise, it may not be any difference. It may be simply just receiving communication or perhaps taking pictures from above. Satellites can do that as well. So what's the point of using or exploiting that near space zone or area? I have no idea. I'm not a Chinese. I have no interest in or intelligence coming from Chinese authorities. But those what we consider as a new threats are not necessarily new threats. In the 60s, I like 60s, and in the 60s there are a lot of incidents of national airspace violations. But at that time, the issue was whether it is lawful to shoot down civilian aircraft entering by mistake into another state's national airspace. But no state questions the state's ability or the right and authority to shoot down any other types of entity entering into their own national airspace. So I think it comes down to the question of capabilities. Do we actually have a capability to destroy or shoot down those balloons or any other entities entering into our national airspace? If we do have that capability, then we should exercise it. If you say that the law is ambiguous in this area, we have to build the state practice. That state practice is built on effective exercise of sovereign authority. So if we simply just let them go without taking any action, that may become a sort of accepted practice. The other states may start thinking, well, okay, we can actually fly those balloons over their national space. And it doesn't really have any consequences. Then they would probably keep doing it. That becomes a practice. So we want to prevent that. So to the extent we can technologically destroy or shoot down or otherwise interfere with the entry of those foreign entities, then we should be doing it as part of the state practice.
All right, thank you. Commander Reynolds, Chris, I don't know, one of you wants to? Reynolds.
During that particular operation, I was the Force Judge Advocate for Commander Second Fleet. And I'm delighted to say that my Assistant Judge Advocate, Lieutenant Elizabeth Madrell, as well as my Deputy, Lieutenant Commander Nicole Agricoli, were the Judge Advocates on the watch floor for the debris recovery after the Air Force shoot down of the balloon. So the chain of command here is important because it articulates the overlapping and adjacent legal frameworks that come into play in a military operation of this kind. And again, to go back to Homer Simpson, space is finite for military operations so far. Part of the reason, just Tracy Reynolds' opinion here, that we don't have a treaty that articulates the demarcation line between terrestrial operations and outer space operations is because of technology. And in my view, which is a part of the Navy culture of preserving commander's decision space, is we don't want a rule that's changed because of technological innovation that turns around and restricts a commander's decision space, because we're already going from a land domain to another area over which there's sovereignty, which is the national airspace, into an area outside the jurisdiction of any one state, which is outer space. And that's something that the Navy deals with quite often. A lot of our military operations happen in international waters, and international airspace is super adjacent to international waters, outer space super adjacent to that. So when we're thinking in terms of the space balloon shoot down as it occurred off the U.S. East Coast, we have our constitutional authorities through the Commander-in-Chief. Then we have that mission given to the Department of Defense, which was given to the Geographic Combatant Commander, which was NORTHCOM, which was then given to NAV North, Naval Forces North, which is dual-hatted for service authority, man, train, equip types of missions out of Norfolk, Virginia. And then that was given to the Commander of Second Fleet, my boss, but then EOD, the explosive ordnance device operators that would actually be diving in the water. That's EOD, that's Naval Expeditionary Combatant Command, which is a type commander. So Second Fleet was the commander in charge of the debris recovery, but then we also were acting in coordination with the Coast Guard. And the Coast Guard was setting up notice to mariners and other safety zones associated with their Title 14 capabilities, which they're also using in conjunction with their Title 10 capabilities, all under the coordination of the Commander for Second Fleet. So imagine, if you will, this shoot down that was done under presidential authority, is communicated to the Department of Defense, executed on the water off the East Coast, all in an attempt to both preserve intelligent collection opportunities as well as keep people safe. Now, I grew up on a farm too, so we've got that going for us. And where I was raised, my closest neighbor was 3 miles away. But even if you shoot it down over a state that is not densely populated, the weather gets a vote. So there was an attempt to shoot down the space balloon so that the debris would land in international water space at 12.1 nautical miles off the coast, so outside of territorial waters, but in the exclusive economic zone, which also has those high seas freedoms. But then the weather got involved. And so the debris field, which was absolutely humongous, extended from territorial waters out into international water space. So what does that mean? Well, we have this debris field working in coordination with the Coast Guard, who had set out this notice to mariners. We had 2 Chinese merchant vessels that were also in the vicinity My opinion, loitering. Their opinion, we're just sitting here. We're not doing anything. It's just totally coincidental that, we're out here outside of merchant vessel traffic lanes, just, paying attention. There's also U.S. military destroyers, United States Navy Gray Hulls. There's Coast Guard cutters. And then there's tons of these EOD folks just skipping around in their ribs. It's nighttime. So they're in their rigid hull inflatable boats, just hanging out. There's a Coast Guard whose authority is generally stop. But if you don't stop, I'll say stop again, as opposed to, any actual kinetic impacts to be able to protect that area. There's drones that are flying around. Some of them are press looky-loos, but we don't know who the other ones are. So that's another Title 10 authority, 10 U.S.C. 130I, where we're trying to protect all of our vessels that are in the area, whether they're gray hulls or Coast Guard vessels, from any potential impacts of a commercial off-the-shelf drone that you can't tell if its wing's dirty until it's actually either running into you or dropping something on you. And then our merchant vessels that are hanging out on the side. And what do the EOD guys do? Because, they're super excited about going out to do their cool guy stuff. They go blazing through the NOTAM restriction in the middle of the night at 25 knots. And the Coast Guard's like, who is that going over here? Now, so why am I sharing sea stories instead of talking seriously about the law? Because I want you all to know at a tactical level that all of those considerations that are put into place, from the presidential authority down to tactical execution on the water, have staff judge advocate input, Navy, Coast Guard, Air Force, all the way through. But then what happens kind of happens. Now, was there any negative impacts from PRC or other civilian activity? No. But did we have to set up a barrier to keep the press off of the EOD guys when they would come up onto the shore to unload their ribs from debris that they'd collected on the seabed? Yes. So there's all kinds of legal authorities there acting in parallel, in conjunction, and instances where you have to pick one instead of the other because one's applicable and the other is not. And so it's a great example of that necessary coordination, deconfliction, and analysis that, we as judge advocates on the ground have to do. And I would like to just stress one more time before I stop talking. My lieutenant was the one advising on that. My second tour lieutenant, who's an amazing human being. So if there's something that you're thinking about, like in what type of instance you would be applying international law, domestic legal authorities, the law of the sea, air law, it's in the military. That's kind of exciting.
Thank you. Before we go over to a question, assuming we have time, because I know we're really close to the time mark. Professor Borgen, did you have any comments on this one? Questions. Okay, so open it up for questions.
Let's see what we have here.
Hello, thank you all for coming. This is a great panel. I'm a 3L at George Washington University. My question relates to space private actors. I imagine when the Outer Space Treaty was created, there wasn't a lot of private space activity. And so I'm curious how the exponential increase in private space actors could influence the development of domestic and international law.
I'll say one thing very quickly on that. One of the things that's sort of interesting as an aspect of international and also different rules is that the rule for state responsibility in the Outer Space Treaty is different than what we see sort of in terrestrial activity, if I could call it that. So in the Outer Space Treaty, a state is responsible for the national activities of both its government and non-governmental actors. So what that means is that if you have a company that's is viewed as being one of your actors. So that could be maybe on your on your registry. It could be a company that perhaps is organized under your laws. Then those activities will be viewed as state activities. There's state responsibility for that, which means that for countries with a high amount of private actors in space, there's a great importance in terms of the domestic regulations that we put into place, because we could face state responsibility for their acts, which is why there's been activity by Congress and also especially by administrative agencies, although as this maybe goes too far into the weeds, but there's a sort of a moratorium in terms of some new rulemaking in terms of certain areas in space at the agency level. But you have the FCC, the FAA, the EPA that are all involved in various aspects of domestic rulemaking. And it's in part because we're very cognizant of the fact that this will also affect our international obligations as a state.
Unfortunately, we only have a chance for one more question. Let's try the gentleman right now. Brief question.
There was a, after the balloon was shot down over South Carolina last year, there was a couple other balloons shot down shortly thereafter, I think within a couple weeks, one over Alaska that was never recovered and one over Canada. Why haven't we heard more about those two balloons?
Probably because it's classified.
Okay. Well, that had the attractive feature of being very short. I really like to thank the panel. We could, I'm thinking we need to do another panel on space. There's so much more to explore. But we are going to take a break in place and have our last panel come up, which we're going to change gears again. We're going to talk about 702. You heard a little bit about that. And it's an important domestic or international surveillance issue. Thank you very much for the panel.